The minimum tax has the potential of not only subjecting the people to double taxation but also unfairly targeting people whose businesses, for whatever reason, are in loss-making positions to pay taxes from their capital rather than from their profits. An advantage which is enjoyable by others merely because their businesses are thriving. Whereas the respondents may well have identified the virus that had infected the revenue collection system as being the dishonest return of losses by some entities, it was the vaccine that was developed that is inappropriate in dealing with that virus. The solution was not to cast the net wide in order to catch the culprits as well as non-culprits as was done, but to develop a system which was tailored to target only the culprits. To develop a system as was done by the respondents whereby even those for whom the law was enacted, for those was not enacted would thereby find themselves lumped together with the culprits, cannot be said to be a fair legislation. The impugned amendment will clearly lead to favorized and sacrificial victims. Those who are able to pay taxes from their profits will not have their capital affected, while those who are genuinely in loss-making position will be sacrificed at the altar of those dishonestly concealing their profits. The respondents have, instead of putting in place systems that can enable them to detect the dishonest entities, opted for an easier way out by casting the revenue net into the deep sea without bothering what the net will catch, as long as the culprits are caught. With due respect, that is not how to enact a fiscal legislation. A fiscal legislation must be precise and must be specifically targeted to meet its objective. It would seem that the second respondent's argument that the minimum tax is meant to deal with those companies which, though are in tax loss position, are not necessarily in trading loss position. However, the imposition of the tax will also affect those in trading loss position, and to that extent, the tax also violates the right to dignity under Article 28 of the Constitution, since it assumes that all those in tax loss position are evading taxes. Article 28 of the Constitution provides that every person has inherent dignity and the right to have that dignity protected. It is for this court to ensure that all persons enjoy that right. Failing to take into consideration circumstances under which taxpayers find themselves in loss-making position, but instead subjecting them to the same law and placing them in the same class as those whose tax loss is not trading loss, thereby treating them as undifferentiated mass, violates their right to dignity. Accordingly, I find merit in the petitions and I issue the following orders: a declaration that Section 12D of the Income Tax, as introduced by the Finance Act 2020 and amended by the Tax Laws Amendment Act 2020, violates Article 201B1 of the Constitution and is null and void. A declaration that the failure by the respondents to comply with the provisions of the Statutory Instruments Act renders the minimum tax guidelines null and void and of no effect. An order prohibiting the second respondent from implementing or further implementing, administering, applying, or enforcing Section 12D of the Income Tax Act as amended by the Tax Laws Amendment Number 2 Act of 2020. As this matter touches on public interest, there will be no order as to costs, and it is so ordered. So that's basically a summary. It doesn't really